Qualifications. This is our second Qualifications Subcommittee meeting. Just as a reminder, this is being recorded, and if you miss any meetings, ACUS is very efficient, and they have copies of all of our drafts and a copy of the recording from last time that is on their website. So keep that in mind, and I will start by saying that my comments are my own and do not reflect that of my agency in all of these committee meetings. Does everyone have the most recent draft? Excellent, and thank you. We have that all in front of us, so that's incredibly helpful. Any preliminary issues that anyone would like to talk about before we jump into this current Rule 207? All right, hearing none.
Well, Erin, I forgive me. I'm sorry.
No, please.
I was trying to raise my hand. I didn't get it right. Do we want to talk just really briefly about sort of you mentioned everything's public, and I know what you meant. But if comments were to come in from folks not on this committee, is there any reason those couldn't be shared with us and be part of our deliberations?
I would not. I would think, in fact, that we'd want to hear comments from outsiders. I think the more comments we receive and the more quickly we receive them, the better. So I actually hope that committee members are reaching out to their networks and feeling out, especially any issues that might present problems. I think the sooner we find out about those, the better. And we definitely want to put together a product that is going to be adopted and going to be useful and make sense to everyone who's involved. So I think sharing the drafts is fine. And if people are receiving comments, certainly attend the meetings. But also, if you receive some comments or have some thoughts after the meetings, please don't hesitate to email us and be in contact. This is sort of our first stab at working on these rules in the subcommittees, but then the final committee will be looking at it, and the earlier we have information about any concerns and the opportunity to set another subcommittee meeting if absolutely needed, we can do that. So please reach out in whatever way works best for you. Great. Well, let's go ahead and talk about the accreditation of non-lawyer representatives. I think we may need to check some of our rule references, but that may be something we do after we finalize the numbering. I think that 206 maybe should be a 205. The other, just as a refresher, one of the other things that we've changed in some of the earlier rules is that we changed character and fitness to qualifications. So we may want to discuss whether a similar change would be appropriate here. So let me open up the floor and see if anybody has any questions or comments on the accreditation of non-lawyer representative proposed rule. Do we all agree that character and fitness should be changed to qualifications here? Great. And subparagraph C, non-lawyer representatives who do not hold other relevant professional licenses and as permitted by applicable law, the agency may establish an accreditation system to ensure such non-lawyer representatives have the necessary qualifications to serve. All right, just raise hands or jump in if anyone wants to weigh in. Any such accreditation system should include the criteria in Rule 205, as well as any additional criteria the agency deems appropriate and relevant to establish a representative's qualifications. Accreditation may operate prospectively to establish a presumption of qualification for the representative in future proceedings, but not for more than 3 years from the date of initial accreditation. And I did want to stop here and talk about whether we want to have the 3-year limitation, if it should be longer, if it should be shorter. And then the next section is going to talk about revoking that accreditation. So the other option is to leave it open essentially until revoked. Does anybody have any thoughts on or experience with other agencies who do this as to how frequently a representative would need to be reaccredited? All right, hearing no comments, sounds like 3 years may work. If the representative engages in conduct after receiving accreditation that is inconsistent with the accreditation requirements, their accreditation may be revoked by the agency. Does anybody think we need more information or less information in this section? All right, excellent. We do have official comments here, including an example of the accreditation process as the U.S. Patent and Trademark Office. If there are other ones, it might be worth including those. Professor Vrelli?
I was just going to offer what I think is a friendly edit to Part D. Perhaps changes to simplify it. If an accredited representative engages in conduct that is inconsistent, I understand in some ways I'm editing myself here, but as I read it, that seemed cleaner, but obviously I defer to the group.
Yeah, I agree. If an accredited representative engages in conduct that is inconsistent with the accreditation requirements, their accreditation may be revoked. I think that's a good change. A little cleaner. Other comments, comment B, such additional criteria may include evidence of good moral character and reputation or of specific educational or other technical qualifications relevant to the proceedings, as well as whether the representative is accepting compensation for their services. Professor Varelli, did you want to comment again?
Oh, no, I'm sorry, sticky hand.
No, that's fine. I'm wondering if we want to have good moral character and reputation in here. We did remove it from some of the earlier sections and focus more on the education or technical qualifications. Anyone have thoughts on that? Mr. Funk?
It seems to me to take it out would be consistent with what you've done before. So seems like a good idea to me.
That sounds good. Number 3, C, this prospective nature of accreditation is designed as a benefit to representatives who are likely to appear before the agency in multiple proceedings during the applicable time frame. The agency may elect to require accredited representatives to complete specified requirements such as CLE courses to maintain their accreditation during the designated period. Anybody have any concerns about CLE requirements? Right, and D, revocation shall be at the discretion of the adjudicator in a given proceeding or a designated agency official. Revocation should occur if at any time there exists evidence demonstrating that the representative engaged in conduct that would have prevented their accreditation in the first instance. I have a question about whether this should be at the discretion of the adjudicator or whether that puts the adjudicator in a position of lacking independence, or if that's good since they're the one who's seeing the conduct. Anybody have any thoughts on who the appropriate person should be or what is done at any of the other agencies. Well, let's just leave it in as for now. And if anybody has any other thoughts about this, we can go back to them. Now, I know the title, if we scroll back to the, yep, Mr. Funk.
No, don't scroll back yet. I was gonna comment on the discretion issue. As I read it, as I understand it, it means that even though the representative may have engaged in conduct that would have otherwise disqualified him, the adjudicator doesn't have to revoke his ability to be a representative. In other words, this is sort of a one-way ratchet. They can disqualify him or not, depending upon what the adjudicator wants to do. It's not a requirement that he take away the representative's qualifications in light of whatever has happened. Is that correct?
Professor Verrilli, any thoughts?
I think so. I that's how I understand it as well. And that was, let's call that designed to start the kind of conversation that Bill just started, right? So whether leaving that discretion in seemed like a safer position to start from, but I'm as always interested in what agencies do and what people think about it.
I don't have a problem with it. I just wanted to clarify that that's what I thought the thrust of it was to grant this discretion to actually allow the person to continue as a representative, notwithstanding conduct that otherwise might have disqualified him. And I don't, off the top of my head, I don't have any problem with that. I just wanted to clarify that's what I thought it said.
Yeah, and that is what I think it says. And there's a little bit of irony in saying if somebody's already behaved inconsistently, but they may still continue to represent. But that sort of discretion, I think, is something that I've been including as sort of a common thread because of the sort of the variability involved. And that goes to wanting to talk about Lauren's comments too, Aaron, before we move on from.
Yeah, and I just saw that I had you all covering my comments. The comment we have is whether we should include a comment, if not part of the section, that the representatives must agree to notifying the agency of any change in their qualification after accreditation. Further recommend that there be a requirement for an occasional renewal. So that's where our 3 years comes in. And I would agree that, if they lose their accreditation, that's something the agency is going to want to know about. And I would think fairly quickly, like within 30 days of a change in qualification status. The agency must be notified. So I'm not sure if that should be a comment or up in the rules, but I think probably it needs to go up in the rules.
I agree.
That sounds right to me too. And I guess the only question is if in this rule, the agency is establishing the accreditation system. Now, so theoretically, to lose one's accreditation, you would have to lose it from the agency. Right, so that there should be that sort of internal knowledge, but having to be clear about it doesn't create any harm. It seems a little, it might seem it might seem a little inconsistent.
The comment that was made by Lauren was not change in accreditation status, but change in the qualifications.
Right.
And for example, I thought membership in an organization that had been qualified, and if you weren't with that organization anymore, that would change your status.
Right, good point.
I think somebody had their hand up, but then it disappeared. Please don't hesitate to jump in.
Yeah, I had my hand up. that was kind of what I was saying. I think it's, if there's a change in maybe the circumstances that might affect the accreditation status, then that is what the representative is obligated to report. That's what I think I would like to see.
So maybe
So
qualification
circumstances,
status.
Yeah, sorry. So something that has changed, right? That might affect the accredited status of the representative. I think that should be on the representative, some kind of quote unquote ethical obligation that they're then required to report to the agency. And then it's the agency's decision on whether to change their status, right? Does that make sense?
Yeah, to me, forgive me for jumping in, for me, for sure, that makes sense. How about something like a representative must report to the agency any circumstances that could materially affect their accreditation status?
I like that.
Mm-hmm.
And can people hear me? I just had a hotel internet problem. Okay, good.
You're good. Would people agree with within 30 days of the change? That seems from the many bars that I belong to, a pretty consistent standard. Just throwing this out there, some agencies are very large and don't communicate well. There could be agencies where someone appearing in front of, the Boston office is unaccredited, and that is not communicated to pending cases in the California office. Would we want people to be required to report a loss of accreditation to the adjudicator in any pending proceedings? Or is that getting too into the weeds? But I mean, I can certainly see somebody not volunteering that information if they're not required to.
I don't have any objection to that. I think that makes sense for what it's worth.
And I think that would go as probably a second sentence in E.
I wonder if that wouldn't be better as a comment.
Maybe.
Yeah, I think that looks good. The accredited representative must report the change in their status to all offices where they have pending cases. Mr. Funk?
I just change it, instead of saying must report, I'd say the agency may require the accredited representative to report. This is something the agency should consider doing rather than. Good, I like that.
All right. Scrolling up to the top, I want to see if there were any other comments about accreditation of non-lawyer representatives. And I had thought I had seen a comment about the term non-lawyer representative.
Right. So I had two things there.
You did.
The second one
I'm
was
sorry.
that.
I put it on an earlier rule.
No, that's okay. Just scroll to
that.
Okay.
Yeah, I had something about 207 still, if we have a chance, although I might have frozen again.
I'll go back down to 207. Sorry about that.
That's fine. Go ahead, Professor Verley. We can hear you fine.
Okay, good. 2O said that in that comment, we might want to say something like including loss of accreditation. Because we don't mention loss of accreditation in E specifically. And I think it would fair to say loss of accreditation would be a change in status for sure. But just adding, and I'm trying to keep my windows as small as possible so as not to lose my internet connection. But I think that's right. That would fit as a clause right at the end of that comment. If I see her right. Yes. And then that leads us to the second point, Aaron, which is sort of the, and is it okay if I continue on this?
Please.
Very good. I have learned lots of things in this process already, and I'm going to learn many more. One of them is that there is a robust national movement to facilitate the representation of underrepresented people in the civil justice system through the use of the talents of people who do not have legal degrees or are licensed attorneys. The reason I'm not using the phrase non-lawyer is because that movement does not. As I learned that, I thought it was worth opening up the conversation about alternatives to the term non-lawyer. In an ideal world, these model rules would be both sort of a reflection of collected wisdom and sort of a guide forward for other organizations who want to do similar work. So I thought it would be worth talking about, and I know Karen Lash has lots of experience in this, worth talking about alternatives to the term non-lawyer to make these model rules sort of current with the larger civil justice movement.
Are there other terms that may be more appropriate or that are preferred?
So here's the trick, is that the movement that Lou described that's underway in the States, and there's lots of experiments and even some fairly well entrenched programs now. There is no agreement yet on language. So just as while we were sitting here, I was jotting down examples. So there's lay legal advocates, community justice workers, limited licensed legal technicians, qualified tenant advocates, allied legal professionals, legal practitioner, legal paraprofessional, licensed legal advocate. So those are the ones that I know off the top of my head. And so it's not really an option, I think, to simply, reach into the States to see what's the normalized term now. There really isn't one yet. So it makes me wonder if well, we were just using accredited rep because we were talking about agencies that have an accreditation process. And of course, we know some don't. So the only thing I've come up with, and it's hardly creative, and is just permitted representative. And when we're talking about accredited processes, agencies with an accreditation process, it's an accredited representative. But I'm not sold on permitted, but I was trying to come up with something that had the spirit of non-lawyer, yet didn't use that word.
Professor Verrilli?
What about something like other qualified representative?
Mm-hmm.
Not inspiring, Karen, I concede that.
Yeah, we're not going to get to, that's not even a goal. I think it's just that in the States, the point is that there's, been obviously backflips in order to not define a group of people who are, some level of professional in the negative. So it's an attempt to signal that they are a category unto themselves, not as defined negatively to lawyers. So I think
Right.
Other qualified, I'm good with that.
I like that as well, and I think it distinguishes something that we talked about last time, the sort of professional qualified representatives from family members, right? Who are not being paid, who are not
Mhm.
professional or qualified, but merely sort of a someone available. So I like this other qualified representative. I think that's a good placeholder. If we think of something better, I'm definitely not opposed to that. And we may need to look back through some of our other rules and see where we've used non-attorney and if that's something we want to change somewhere else. Mr. Funk?
What you said just raised a question in my mind in terms of representative by a family member, right? That would have been covered by the non-lawyers. Does it get covered by other qualified representatives? I mean, we don't want to eliminate the ability to be represented by a family member, assuming the family member can meet the qualifications that we want.
I think, to me, the difference is a family member isn't somebody who's regularly doing this, so they would maybe make an appearance in one case. Maybe they have multiple family members, a couple cases. But I don't know, Professor Verley, how are you thinking about this rule?
I was going to ask the same question Bill did, and my internet connection is abysmal right now, so I'm losing a little bit of what's being said, and I apologize for that. But my inclination when I suggested other qualified representatives was to include everybody who we've called a non-lawyer in the rules, because we do have Rule 205, which is a qualification provision sort of writ large, right? So a family member could qualify under Rule 205, provided they would, the adjudicator determines that they will, frankly, do no harm, right? Sort of the Hippocratic oath of agency representation. So I meant for that. I meant for a phrase like other qualified representative to include everybody who is not a licensed attorney, including family members who are non-expert, but competent and desirable for the participant. I appreciate the word qualified sounds loaded, right? The word qualified sounds like more like somebody who's a CPA appearing in a tax hearing. That's not what I meant. The reason I used qualified is because it was internally generic, because all of the representatives we're talking about in these rules are qualified under 205. But that's why it's one of the many reasons it's an imperfect phrase, right? Because it does sort of imply a level of expertise that I did not mean to capture, right? That's what the licensing rule, I think, was designed to get at. The other professional license rule, or what did we call it now? Is it just the other license rule? Just non-lawyer representative licenses.
Oh, right, and we took out the term professional.
Mm-hmm.
So I have two, go ahead, Mr. Funk, I'll let you weigh in.
I didn't see the problem with non-lawyers. In as much as it's been demonstrated, there is no agreed upon or preferred way of referring to it. I mean, here we have essentially two tracks. We have a track for lawyers, and which is essentially the Agency Practice Act. And then we have everybody else. And everybody else other than the lawyer is a non-lawyer. So I thought it was a very apt and accurate description of who these people are, because then we have requirements for qualifying for them, and there's different ways to do it, individual cases, be an organization, different licensing systems. I mean, we have all sorts of different ways people can qualify, but they're all non-lawyers. And I thought that, I mean, I don't, if we can't sort of come up with a great term that's going to be applicable across the board, then I don't see a problem with non-lawyers.
So I'll raise something that came up last time, which was we had some discussion about how to handle retired or disbarred lawyers. And by removing the non-lawyer, we do sort of remove that issue. Ms. Davis. Oh, you're
Thank you. Just a couple of observations. One is that other qualified representatives is pretty consistent. I had shared some materials between sessions with Alexandra and Professor Verrilli and you regarding the work that LSC has kind of done in this area in thinking about ways that we involve people who are not practicing attorneys in our grantees work to bring new people to the fold to improve the services that they're able to offer their clients. So I think we would be, I'm completely fine with other qualified representatives. The other thing that I would say is that, you know, kind of what is who is going to be seeing these rules and what are they going to be thinking of them? And the reason that I say that is that we, in our experience, work a lot with non-attorneys who are very qualified and have a lot of good lived experience and bring a lot to the table. And they have expressed that the phrase non-lawyer seems almost pejorative, like they're in a somewhat different class. And I think that there may be some qualified representatives who would wonder if, you know, who would wonder whether the standards were different or whether adjudicators would consider them and their qualifications differently. Even though they're qualified, they're non-lawyers. And so I just offer that from our perspective.
Ms. Lash?
Yeah, I would just add that I agree with Stephanie, obviously, and appreciate the work that the Legal Services Corporation has been doing around this issue as the movement grows. It seems like if we kept non-lawyer, it would be obviously out of step with what's happening nationally. And if we can come up with an alternative that, and I think Stephanie's right, is that the reason that states are turning themselves inside out to avoid non-lawyer is because it's perceived as pejorative to now thousands of people who are, developing expertise. And so that's the reason for it. So it would look like we're not paying attention and really behind, I think, to continue to use it.
Mr. Funk, if I can put you on the spot and see if you have any specific concerns with the other qualified representative language.
Well, I just trying to read down where we use non-lawyer. It seemed to me might be some problem with using the term other qualified representative in lieu of that, but I'm sure that can be worked out. I mean, as I heard, I guess it was Leah run through the various expressions of this term, I sort of like lay advocate as a nice short way of referring to these people, because these are all adjudications, and so therefore it is always an advocate in that sense, and they are lay in the sense of not being attorneys. Now they may have another qualification license, all right, which lay would mean non-attorney, and we could even put that as a definition. But I thought, I mean, is that a, I mean, I don't want to, denigrate anybody, because I fully support non-lawyers doing this stuff. Would lay advocates sound good? Would they like that? Would that be better than just other qualified representative? In any case, I certainly don't have any problem with the concept of getting rid of non-lawyer for something that's more positive, as long as we can figure out how to work it in everywhere it applies.
Ms. Lash, were you going to weigh in?
Yes, it does make me wonder, since now it's all right for, we've clarified that it's okay to check in with people who are not members of the working group, that maybe that's something to kind of float among some of the leaders in this national effort, and state leaders, to see. I was thinking representative work just because the word has been used throughout the rules and is at least picking up some legacy language so that it's a little less abrupt of a switch. But I'm happy to check in with some folks. I'm kind of partial to lay advocate. It's a little less, fewer syllables, but it just, I think representative allows for a little more consistency. But I will take on that task.
My only question with lay advocate is whether if states are using that as a definitionally, whether their definition would be consistent with ours. So for example, if we're considering family members, but a state has a training or other sorts of requirements for lay advocates, so that would just be I think a question to look into.
You know, it's more it's in the crime victims movement that the lay legal advocate or lay advocate is where I see it the most. And the Justice Department, the Office for Victims of Crime, they use that language. I'm not sure I've seen it elsewhere, but I may be worth doing a little more investigating.
So I suggest that we sort of table this with a couple options, particularly because whatever we decide, I think is going to be a term that's used throughout. So so let's keep this as something that we continue to discuss before we make changes throughout the section. Any final words on that, or any disagreement with moving on? All right, so rule 208, I think we're on accreditation of organizations. So these, yeah, perfect. The agency may provide accreditation for organizations, which may in turn designate members of their organizations as representatives in agency adjudications. If the agency decides on its own to pursue accreditation for an organization, it should require the organization to submit documentation to the agency establishing that the organization meets the accreditation requirements. An organization may submit a request for accreditation to the agency. Such request for accreditation must be accompanied by documentary evidence from the organization establishing that it meets the accreditation requirements of Rule 210. Any comments or concerns about this section? All right, we do have a comment about the Department of Homeland Security, Department of Justice, Executive Office of Immigration Review uses organizational accreditation to identify representatives in immigration hearings. Mr. Funk?
Sorry, I couldn't get my hand up fast enough.
No, that's fine.
In A2, where it says documentary evidence, I just thought documentation. I mean, it just doesn't seem like something we need evidence. We don't need to use the term evidence there.
Yeah, that's excellent. Any other suggestions for this section?
Just that I think Rule 210 should be 209 in both cases, but that's going to be a larger project at the end of all of this either way.
Agreed. All right, if this section works for everyone, we can move on to 209. And this is the requirements for organizational accreditation. Any comments before we jump into it? So this is for nonprofit, religious, charitable, social service, or similar organizations established in the United States, may be accredited by the agency to designate representatives to participate in agency adjudication And let me see, I want to make sure, oh, I have missed some comments. I apologize. My screen's not big enough to manage everything. Somebody is curious if there are reasons against expanding organizational accreditation to private law firms. Mr. Funk?
My comment was going to be, I agree with that comment. Law firms often have give pro bono, have people do pro bono work. Sometimes they even have people whose only job is to do pro bono work. At least once upon a time they did. So I would think that that kind of thing would be equally true.
I agree, and I think that is something we would want to encourage. So perhaps list yeah, they wouldn't fit. Yeah. Law firms or nonprofit organizations with our list of potential organizations. Does that cover that issue?
That was my comment, and I think it does. Yes, thank you.
Excuse me, this is Diane Boyd-Rober. I'm with the National Organization of Veterans Advocates. So I just have a question about whether you are considering those as law firms that are strictly doing pro bono work, or law firms that are doing this as private practice. And then second, I may be looking at it from a slightly different perspective just because of some of the issues we have with unaccredited claims consultants and people who are operating outside the structure of the law. But then how does that impact practices where they are not attorneys, but they are more like a accredited agent practice?
That's a good question. Anybody have any thoughts?
Well, on the first issue of whether it was a law firm doing pro bono work, I think A2 is what makes sure that the law firms, to the extent they're included, would be doing this on a pro bono basis. So I think that's what takes care of that, as opposed to just doing regular business. With respect to the second question, I didn't quite understand it. My fault, not the speaker's fault.
I think no. I think that I think by making that statement, you've clarified the concern that I had. So thanks.
We did have, okay. So let's stick with this little section here. Law firms or nonprofit, religious, charitable, social service, or similar organizations. Do we need the established in the United States? I don't know if there are any of these that are established elsewhere. It doesn't seem like there would be, but
I think there may be, if I remember from my research, and this is coming from DHS, so that might be sort of explanatory in its own right as to why it said established in the United States. We could put in a comment that some agencies prefer to only accredit organizations that have been established in the United States, if we don't like it in the rule.
yeah, it's not, I think that's a good comment. And it's not surprising it would come up in the immigration context. I see that as something that may be difficult to establish. In other words, is that something they're going to have to show, or if there's some sort of, I don't know, international organization that's helping provide legal services in multiple countries or something, you know, is that going to be a problem? I guess I'm just not sure. Do other people think it should be in the rule and that we'll have a way to document that? And I'm fine if we leave it in. There's a comment about strongly cautioning against a practice, but I can't tell what that comment refers to. Can
So
anyone?
unfortunately, Miss Alder Reed was, I guess, is not able to join us today. But I copied the comment onto the words that she had copied it, that she had placed it on. So it's on the may be accredited by the agency wording.
Thank you.
Yeah, no problem. I'm sorry. It's not too clear with all of the comment bubbles in here.
Yeah, I couldn't tell what matched up. I mean, I think this section is talking about agency accreditation, so that would be a pretty significant change to try to remove that. I'm not sure this rule is going to be the place to deal with any issues with particular agencies about how they implement, other than if there's some way we can clarify or make that implementation better through the rule. But I'm certainly open to suggestions.
We may just want to think about the structure of this section and having this be easily severable for agencies that didn't want to adopt, for example, this model rule. This particular rule within the models. And I think it would be, but I'm going back and checking myself as I say it.
The other comments we have are that DHS does not accredit representatives, and that it would be very difficult to make this determination in real time. I think that has to do with whether an organization no longer meets accreditation requirements to participate in adjudications. And this may go back to a similar issue that we added in Rule 207 about notifying the agency or the adjudicator if an organization loses accreditation. Yeah, so that might make a change to B. We could put a time frame in there. If an accredited organization within the meaning of subsection A no longer satisfies the accreditation requirements, representatives designated by the organization shall no longer be permitted to serve in agency adjudications, and the organization's accreditation shall be revoked until such time as the organization is able to come into compliance with those requirements. I feel like we need a notice sentence in there that the organization and any representatives are required to notify, I think we said before, the office in which there are any pending cases or proceedings or something. I would use similar language.
Put that in the comment.
Yeah, and I think Mr. Funk is, yeah, within 30 days, that's perfect. I think Mr. Funk is right that we put that in the comment last time and said that the agencies may consider adopting.
That sentence stays in there, but then in the comment you put in the idea of notifying various offices as opposed to just the agency.
All right, so let's look at the language in the rule first. We added the organization and any representatives are required to notify the adjudicator, I think, within 30 days. Go ahead, Mr. Funk.
Did I understand Lauren Alder's comment to suggest that she was concerned about this section seeming to require agencies to accredit organizations?
I don't know that I read it that way. My impression just overall of the comments, and I have no idea if this is what she intended, is you wouldn't, and just putting it more generally, you wouldn't want an agency who, for example, decided to unaccredit agency, an organization because they didn't agree with their views or because of
Well,
the
that's
types of
true.
cases they took, or for some sort of political or something that would be an inappropriate reason. I
just wondered if I wondered if this was her concern, that at least you could make it easier by saying, having A read, an agency may consider accrediting blah, 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 blah. In other words, start off the sentence saying an agency may consider crediting.
But I think my thought is that if the agency is going to adopt this rule, they would adopt the rule and the language in it. So to me, the agency may consider accrediting is somewhat implied.
Yeah, okay, I grant that's true.
But I agree that certainly not all agencies are going to go through the process of setting up an accreditation system like this. All right, any other comments? Mr. Funk, did you have another comment?
No, sorry.
Okay, no, that's fine. All right, any other thoughts on this section or on the comments that we have?
Mr. Cohen has his hand up.
All right, go ahead. And I think you're muted, Mr. Cohen. There you go.
Yeah, I just had a question about, would it make sense to include clinics at law schools here, or is it sufficiently covered in the student section that you don't need it?
That's a very good question. We do have a specific rule on students.
It does say students who are under supervision of a faculty member and don't receive compensation. So we might be worth including, checking to make sure there isn't a comment there. It might be worth including a comment that this includes clinics, or it might be that we're only limiting ourselves with that comment because it does and could be broader than that. But I defer to Professor Cohen on that.
Well, I don't have a strong opinion on it. I just thought it was worth raising.
I agree we should mention clinics somewhere so that it is clear that they're covered by one of the rules. And my guess is if a law student or I as an adjudicator were looking it up, and I had somebody from a clinic, I would look at the law student rule.
Right.
So maybe in the comments, say that this would include
students in a clinic externship or supervised pro bono program.
Yeah. All right, any concerns about that? That's a good catch.
It is. I agree. I would humbly edit that to just say, I would leave most of it. I would just humbly edit it to say participating in a supervised law school clinic, externship, or supervised pro bono opportunity. Just because clinics and externships are terms of art in the academy.
That sounds good. So looking at the time, I believe we scheduled this for an hour. We have about 5 more minutes, but that's perfect because I think if we scroll down to requirements for organizational accreditation, I believe that was our last section that we wanted to talk about. Do we have any other comments on this rule or on any of the rules we've talked about today? Yep, go ahead, Mr. Cohen. You're on mute still.
Yeah, I wanted to go back to 207 for a second
Mhm.
and subsection C, and this is it says accreditation may operate prospectively. The other sections all seem to talk about the agency doing it. This doesn't clarify that it's the agency. The agency may decide that accreditation may operate prospectively. So it, just to be consistent with the other language, maybe we should change that.
Yeah, that's good. Excellent. In our last moment or two, is there anything else? Well, I guess we really don't have time probably to get into any other discussion of the earlier sections, but I would encourage you to email Professor Vrille and ACUS and myself if you do have any other comments or want to share comments from any other entities or people that want to weigh in. Again, we really do want to hear from as many people as possible. And I appreciate those who will think more about the term non-lawyer representative and what may be the best fit for that piece. And that's something we will discuss again. At this point, the schedule is that we have now our solid, I would say, draft of this section, the qualification section, and we'll be moving on to the conduct and ethics sections next. You are all welcome to join us when we have those conversations. We really appreciate the input and we appreciate your willingness to share your thoughts with us. So please feel included, but you are not obligated, having weighed in so effectively and helpfully on the qualifications section. So I will be turning to the conduct and ethics next. At the end, of course, we'll see how it all fits together. And we may have more changes to this section coming up at a later date. Mr. Funk?
Yeah, as I mentioned, in this draft, there are comments in the margin with respect to previous sections that we didn't talk about today. And it doesn't appear that some of the comments were addressed. And my question is, were those comments addressed and just rejected, or what? I mean, I just to take an example, there was a problem with the word inexpensive representation in Rule 102. And it just 102. And
Mhm.
and the inexpensive, was that rejected?
So the first 3 rules, 100, 101, and 102 are part of the general provisions that are going to apply to all of the sections. So Professor Vrille and I talked about this a little bit. It's a little chicken and an egg issue. We have not specifically gone over those. Some of them are definitional. We just jumped in last time to Rule 200 and focused on the qualifications. I think our conversation about the qualifications may have changed or brought some issues up into those first definitional sections. So my guess is that those rules 100, 101, and 102, those will undergo changes, and we have not finalized those terms yet. And I think that conversation, we talked about whether we should have that sort of first or later. And I think having that a little bit later and having our other conversations inform that is where we are. So at least for those 3 sections, which I do know there will probably be a good number of comments on,
Okay.
we have not had a chance to review those.
Then I just want to say on section 203, the official comment number 1, it refers to character and fitness. And I seemed like that we didn't want character and fitness anymore.
And that should be changed to qualifications. Thank
Okay.
you.
All right. That's all I have.
That sounds great. I appreciate it. I really appreciate everybody's comments. And of course, we are getting comments after the fact. And so, as drafts are, when you have multiple people contributing, it may be a little bit messy as we move forward. But I have confidence that with Professor Varelli's excellent assistance, we'll be able to pull it all together and tie it all up. Thank you again. I've really been very pleased with the active participation we've received from everyone. It really helps us. It helps ACUS, and hopefully we'll make this process easier down the road. So thank you all. I think we're right at an hour. I don't want to go over. Everyone enjoy the rest of your day.
Thank you, Aaron. Thank you, everyone. Thank you, Lou. And thank